Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be our lecture number 27 in the series Indian Polity, and today we are not going to discuss any particular topic, but today we are going to revise whatever you have seen in the previous lectures, and we are going to revise it in the form of what is called as practice questions. I've already said that the practice questions are very important, and it is because of lack of practice most of the times number of serious candidates are not able to do well in the examination. So practice is something which should be integral part of your preparation. That is why I'm making it as a practice that every week we at least do one practice questions, a set of 20-25 practice questions from my side, but I will also suggest you to do more practice questions. Because when you practice, you also understand that whether your conceptual understanding is right or wrong, and what are the areas you get to make the mistakes. And once you know these are the areas that you make the mistakes, so that the chances are very high that you will not make such a mistakes when it comes in the examination. All right. So that's the objective as to why we are doing this practice again and again. So we'll move to the practice questions. But before I move to the practice question, as I used to say in my previous lectures also, that the larger objective of this particular series Indian Polity is to provide you a comprehensive idea on this particular subject, covering not only the Indian Constitution but also the important books like LAXMIKANTH will be in detail analyzed and covered through this particular series. And this will be really helpful to the students preparing for UPSC examination as well as the other competitive examination. And with that, we'll get into the practice question. So we have 20 practice questions today, especially covering the topic of fundamental rights, whatever we have seen in the fundamental rights till this point of time. We have not completely covered the fundamental rights. We have just seen the features of the fundamental rights. We have tried to understand as to what is Article 12, what do you understand by what is a state under Article 12, what is Article 13, what is a law under Article 13, and how the primacy is given to the fundamental rights under Article 13. And then we have tried to understand the first theme of fundamental rights. We have seen 5 rights so far this till this point of time. Under the right to equality, that is equality before law, equal protection of law, no discrimination on certain grounds by the state under Article 15, equality of opportunity in matters of public employment under Article 16, abolition of untouchability under Article 17, and abolition of titles under Article 18 of the Constitution. So these are the things that we have seen, but again it's very important. UPSC will ask probably 1 or 2 questions. A lot of questions may also come in the state service examination from these areas. So to that extent, we'll just go to the first question. The major objective of fundamental right. So what is the major objective of the fundamental right? So we have clearly seen that the major objective of the fundamental right is to restrict the arbitrary action of the state. The fundamental rights are mostly protective in nature. It protects the individuals, the people, from the arbitrary action of the state. And that's why, if you remember, we also discussed that the fundamental rights are nothing but the Magna Carta of India. So Magna Carta is a legal document that was signed way back in 1215. A charter, a great charter, which was signed in 1215 between King John and the rebellious barons or the nobles at that point of time, trying to protect the rights of the nobles and the ordinary people. So similarly here, if you see the fundamental right to be the Magna Carta, which means it's basically designed in such a way to prevent the state from exercising its powers in an arbitrary manner. So with that, come to the question, limit the actions of the citizens against the state. No, that is not at all the objective. The objective is what? The objective is to limit the arbitrary action of the state. Limit the action of the state against the citizen. So this is definitely there. Empower the judiciary to protect the constitution. That is not the power of the fundamental rights. Of course, this is a provision in the constitution, but that is not the objective of the fundamental rights. So the answer would be option B. Option B is the right answer. All right. So let me choose the green color. Okay, so come to the next question. Which of the following shall not violate the fundamental rights of the citizens as per Article 13 of the Constitution? So which of the following shall not violate the fundamental rights as given in the Article 13? So basically, for which you'll have to understand what is Article 13. What is Article 13? If you see the very crux of Article 13, Article 13 is providing primacy to the fundamental rights. And how Article 13 is providing primacy to the fundamental rights? Because Article 13 is saying that if any law in violation of the fundamental rights, those laws can be declared to be invalid by the courts, and to that extent it is giving the power of judicial review to the courts. So the very purpose of Article 13 is to see that the laws are not in violation of the fundamental rights. So what are the laws that shall not be in violation of the fundamental rights? So basically, to answer this particular question, you should know as to what is defined or what shall fall within the definition of law under Article 13 of the Constitution. So we have already seen what are the things that will fall within the definition of law under Article 13. Laws made by the Parliament and the laws made by the state legislature. Not only the laws made by the Parliament, but also the law made by the state legislature. Ordinances issued by both President and the governors. Laws in the form of what is called as delegated legislations. That is also covered under Article 13. And we have also broadly seen as to what is a delegated legislation. So basically, these are rules made by the executive authorities or rules made by an authority where the parent law is delegating this authority to make the rules. And then constitutional amendment. So what are the things that is there in Article 13? Laws made by Parliament and state legislature, ordinances issued by the President and the Governor, and then we have also seen that the delegated legislations, and then non-legislative sources of law in the form of customs also is part of law under Article 13. But we have clearly seen a constitutional amendment is not a law under Article 13. That means when I say a constitutional amendment is not a law under Article 13, which means by a constitutional amendment under Article 368, a fundamental right can be taken away. And that constitutional amendment cannot be challenged under Article 13 of the Constitution, and it cannot be struck down by the courts. But however, if an ordinary law or any of the other things which is defined as law under Article 13, if they are violative of the fundamental rights, then the courts can strike them as invalid or null and void. So this is basically what you'll have to understand. So choose the correct answer from the codes given below. So what would be the answer in this case? Option C is the right answer. That is 1, 2, 1, 3 only is the right answer. Come to the next question. Which of the following fundamental rights are available only to the citizens? So this is one of the important feature probably you'll have to remember with regard to the fundamental rights, that while all the rights are available to the citizens, whatever is the right in part 3, right from Article 12 to Article 35 is part 3. And whatever fundamental right that is available in this particular part, all the rights are available to the citizens. But there are certain rights among these rights which is also available to the aliens. But there are certain rights which are exclusively available only to the citizen. That is what you'll have to understand. Which of the following fundamental rights are available only to the citizens? So while most of the rights are available to both citizens as well as the aliens, but some of the rights are exclusively restricted only to the citizens. And what are those rights? So we already seen it is Article 15, that is no discrimination by the state on certain grounds under Article 15. Right to equality in matters of public employment under Article 16, and then the right to freedom under Article 19. There are 6 sets of freedom under Article 19. Right to free speech and expression, right to freedom of movement, right to reside anywhere within the territory of India, right to form association, union and cooperatives, right to assemble peacefully and protest, right to carry on any trade, occupation or business. These are the 6 sets of freedom that is guaranteed under Article 19 of the Constitution, that is again to the citizens. And then apart from that, Article 29 and Article 30, which provides for set of minority rights. Minorities in India are protected by these rights, and hence the right answer would be Article 15, 16, 19, 29 and 30. So this is the right answer. So if you apply that, option D is the right answer in this particular case. Come to the question number 4. Consider the following statements regarding the fundamental rights. The fundamental rights are absolute in character. So this is also one of the feature that you have seen, that the fundamental rights are not absolute in nature, but they are qualified in nature. What does it mean when we say that the fundamental rights are qualified in nature? When we say that the fundamental rights are qualified in nature, the rights, though guaranteed in Part 3 of the Constitution, these rights also comes with some reasonable restrictions. In fact, most of the rights do comes with what is called as reasonable restrictions. And on the ground that is mentioned in the Constitution, they can be reasonably restricted by the state. Say, for example, I have given this example during the discussion. Say, for example, we have the right to freedom of speech and expression. But in the name of right to freedom of speech and expression, we cannot engage in what is called as contempt of the court. In the name of right to freedom of speech and expression, we cannot disturb the public order. In the name of freedom of religion, we have the right to freedom of religion, but in the name of right to freedom of religion, we cannot forcibly convert people from one religion to another religion. So these are all some of the reasonable restrictions that is mentioned in the Constitution itself. So similarly, for different rights, different reasonable restrictions are mentioned, and to that extent, we'll have to keep this in our mind, that while the rights are guaranteed under the Constitution, but these rights are not absolute in character, but rather they are qualified in nature. They cannot be suspended under any circumstances. So this is also one of the features that you have learned, that while the rights are there, and the fundamental rights are important, no doubt, but the fundamental rights can be suspended, and when they can be suspended during what is called as emergency. So during national emergency, the fundamental rights can be suspended. So this is basically what you'll have to understand. So national emergency can be proclaimed by the President of India under Article 352. So whenever the national emergency is proclaimed, certain types of fundamental rights can be suspended, and that's an elaborate provision which we'll subsequently discuss. But yes, they can be suspended during what is called as emergency. Third thing is they can't be amended. So when you say that they can't be amended, of course the fundamental rights can be amended. There is no doubt in this particular regard. In fact, right to property was taken away. Right to education was brought in by inserting Article 21A by the 86 Constitutional Amendment Act. So when you say that they cannot be amended, so this is also wrong. So all the three statements are wrong. Choose the correct answer from the quotes given below. So what is the correct answer? So consider the following statements. Choose the correct answer from the quotes given below. None of these options are right options. Okay. So the answer would be option D. Come to the next question. Question number 5. Which of the following are the features of the fundamental rights? So we have seen number of features of the fundamental rights. One is, are they justiciable in nature? Of course, the fundamental rights are justiciable. Not just the fundamental rights, even the constitutional rights, the legal rights, whatever you have discussed, they're all justiciable in nature. There's no doubt. But what is the uniqueness when it comes to the fundamental rights? In case of violation of fundamental rights, the affected individuals can directly approach the Supreme Court of India under Article 32 of the Constitution. So under Article 32, they can approach the Supreme Court. And if the citizen want, they can approach the High Court also, and that they can do under Article 226 of the Constitution. So they are definitely justiciable in nature. Statement 2, available only to the citizens. When you say available only to the citizen, that's an absolute statement. So the fundamental rights are not only available to the citizens, it is most of the rights in fact are available to the aliens as well. Only some of the rights are exclusively available only to the citizens. We have seen that. Article 15, 16, 19, 29 and 30. Apart from that, the other rights may be available to the aliens as well. So available only to the citizens is wrong. They can be enforced only against the state. So again, it's an absolute statement. So when you say enforced only against the state, in fact, most of the fundamental rights are only against the state. There's no doubt in that. But again, it is not an absolute concept, because some of the fundamental rights can also be enforced against the private individuals. Say, for example, right against exploitation, that is right against practices like human trafficking, forced labor, child labor, and of course, abolition of untouchability. So these are all some of the fundamental rights that is not only against a state but also against a private individuals. So but to say it is only against a state would be an absolute statement. So again that is wrong. So choose the correct options from the quotes given below. So the right answer is option 1 only. A is the right answer, or 1 only is the right answer. Come to question number 6. Which of the following fundamental right is the heart and soul of the Constitution? I already explained this when I was talking about the features of the fundamental rights. In fact, in the opinion of the Dr. B.R. Ambedkar, one right is very, very important. And if that right is not there, the other rights may not be not of much use. What is that particular right? That is the right to constitutional remedy, which is there under Article 32 of the Constitution. So under Article 32 of the Constitution, it is our fundamental right to get it enforced in a court of law whenever the other fundamental rights are violated. If you see, except for Article 32, other fundamental rights are only conferring us some right. But the question is, what if these rights are violated? Then what shall we do? So when these rights are violated, we can get those rights enforced in a court of law. That is also a fundamental right under Article 32 of the Constitution, wherein we can directly approach the Supreme Court and seek a direction from the court to issue different types of writs in order to protect our fundamental rights, or in order to get remedy in case if the fundamental rights are violated. In fact, the Supreme Court can issue 5 types of writs under Article 32 of the Constitution. If you know those writs, you can put it in the comment box as to what those writs are. And we'll see these writs elaborately when we'll proceed with the topic of fundamental rights. So the answer here is option D in this particular case. Come to question number 7. Which of the following are the criteria that politically explains the concept of state? I'm not looking for the definition of state under Article 12. If you listen to my video, we'll try to understand as to what is the definition of state under Article 12. But the question here is, it is not asking what is the definition of state under Article 12, but what is the political science, or politically how would a state be defined and what are the characteristics of a state? This also we have understood. Sometimes in the UPSC examination and in other state service examination also, they can ask this type of question also. In UPSC it has already been asked. Now politically, how do you define the concept of state? A state should have a defined territory. A state should have a community of people, and there should be an established government based on which the people of that particular territory is governed. And most importantly, that the state, that the entire way that they are governed should be sovereign in nature. That means the state is independent of taking decisions both internally as well as externally, and then only you call that as what is called as a state. So what are the things that probably explain the definition of or the concept of state? Sovereignty, yes. Territory, yes. Defined people, yes. It should have its own government. Not necessarily a democratic form of government, any form of government, but they should have sovereign power. So choose the correct answer from the quotes given below. So the right answer in this case would be option D. But however, if a question comes, what is the definition of state under Article 12 of the Indian Constitution, then you should refer what is given in Article 12. But if they generally ask you what is the definition of state, politically means this is what you should understand. Please come to the next question, question number 8. Which of the following is not true regarding the fundamental rights provided in the Indian Constitution? So the question is asking which of the following is not true with regard to what is called as the fundamental rights provided in the Constitution. Statement A. Inspiration drawn from the Constitution of USA. Of course, we have drawn the inspiration of our fundamental rights from the Bill of Rights in the American Constitution. So definitely this particular statement is true. But it is asking which of the following is not true. So this cannot be the answer. All rights are justiciable. In relation to fundamental rights, of course, yes, each and every single fundamental right is justiciable. Whenever any of the right is violated, we can approach the courts. We can approach the Supreme Court under Article 32, and we can also approach the High Court under Article 226. So this is also true statement, but in relation to what is asked, it is not right. It is the Magna Carta of Indian Constitution. I already discussed. It is the Magna Carta of Indian Constitution because the fundamental rights are aimed at restricting the powers of the state, and definitely it is the Magna Carta. And that is why the Magna Carta, the great legal charter or the legal document was signed in UK, is aimed at restricting the powers of the king. So similarly here, the fundamental rights are aimed at restricting the powers of the state. So definitely it is also considered the Magna Carta of India. So the statement is right, but in relation to the question, it is wrong. So what is the answer here? So the answer would be none of the above. Option D is the right answer. Please come to the next question, that is question number 9. Which of the following are the objectives of the fundamental rights? So what are the objectives of the fundamental rights? Statement 1. To give directions to the state to make welfare policies. It is definitely not the objective of the fundamental right. It is the objectives of the directive principles of state policy. If you see the part 4 of the Constitution, students who have listened to my previous lectures, they will be able to answer this. The part 4 of the Constitution talks about what is called as DPSP, and the very objective of DPSP is to give some kind of directives to the state, and so that the state can make welfare policies in this particular regard, and automatically it will lead to the welfare of the people. But again, it is a non-justiciable part. But however, it is not the objective. So whatever mentioned here is the objective of DPSP, not fundamental right. To limit the powers of the state, of course, it is the objective, and that's why we call the fundamental rights to be the Magna Carta of Indian Constitution. To empower the citizens against the arbitrary action of the state, is that a fundamental right? To empower the citizens against the arbitrary action of the state, which is similar to that of restricting the powers of the state. So this is also an objective of the state, objective of the fundamental rights. How many of the statements given above are correct? So statement 1 is correct, but statement 2 and 3 are correct. So the answer is option B, that is 2 only. So here I am marking option 2 only. Option B is the right answer. So please come to question number 10. We are in the middle of the discussion, and this would be really useful to the students if you already watched the lectures. If you watch the lectures and coming and doing the practice question, it will be effective to you. But if some of the students have already learned these concepts, then they can also take up the practice questions. Right to property was deleted as a fundamental right by which constitutional amendment act? The right to property was guaranteed as a fundamental right under Article 31 of the Constitution, and along with Article 19, Clause 1, Subclause F. But however, this right to property no longer continues to be a fundamental right. Can anyone tell me what is the status of this fundamental status of right to property today? Right to property even today continues to be what is called as a constitutional right. And where this right to property has been placed right now, that is Article 31 was taken out of Part 3 of the Constitution. Today it is placed under what is called as Article 300A, but outside Part 3. And Article 19, Clause 1, Subclause F has been completely repealed from the Constitution. It is no longer in the Constitution. Both these amendments has happened by the 44th Constitutional Amendment Act in 1978. Okay, so the right answer is option C. Okay, so the answer in this particular case is what? The answer in this particular case is option C. Option C is the right answer. Come to the next question, question number 11. Which of the following will fall within the definition of state under Article 12 of the Constitution? So for which you should know what is there in Article 12. Without knowing what is there in Article 12, you will not be able to answer this question. But before we see as to what is there in Article 12, we have already learned as to what is the objective of having this article. The objective of having this article is to define the term state, and thereby we know who are all state actors. And if something is done by a state actor, and if that action is violative of fundamental rights, so we can approach the courts. Why? Because most of the fundamental rights are only against the state. I'm not saying that all the fundamental rights are only against the state, but most of the fundamental rights are only against the state, except a few fundamental rights which can also be enforced against a private individual. Say the right against untouchability or abolition of untouchability is one such example. So if you see Article 12 of the Constitution, what are the things that falls within the definition of state? Government of India, yes. The government of states. Parliament, yes. In addition to Parliament, state legislature also, but it is not given here, but that also falls within the definition of state. Local bodies, yes. Panchayat and municipalities, the authorities under that. Public sector undertaking, yes. Largely they will fall within the definition of state based on the criteria that the Supreme Court has given, because the shareholding of the government, the control of the government over these organizations in terms of the appointment and all those things. So by seeing with regard to all those things, the public sector will fall within the definition of state as per the interpretation that is given by the courts. But what about private companies? So private companies normally does not fall within the definition of state, except for one circumstances. So that is an exceptional case. So whenever the question is asked, don't take up the exceptional case, just see the general rule. So generally, the private companies do not fall within the definition of state, unless and until they act as an instrument or an agency of the state, unless and until they are performing duties which are similar to that of the governmental duties, or they are helping the government in discharging their duties and responsibilities. Unless and until they do that, they do not fall within the definition of state. So to that extent, this 6 is not the right thing. So, but however, what would be the right thing? 1, 2, 3, 4 and 5. So choose the correct answer from the codes given below. So the right answer would be what? In this case, 1, 2, 3, 4 and 5 only. That is, option B is the right answer. So other things are not the right answer. I hope that this is very clear to all of you. Please come to question number 12. Consider the following statements. The judiciary falls within the definition of state under all circumstances. Although it is not explicitly given in the Constitution, the Supreme Court has made it very clear the judiciary will fall within the definition of state when they are performing what is called as the administrative functions. So when they are following administrative function, yes, they may fall within the definition of state. But when they are performing the judicial functions, they may not fall within the definition of state. So judicial functions, they will not fall within the definition of state. Administrative functions, they will fall within the definition of state. So here the question is saying that the judiciary falls within the definition of state under all circumstances. That is wrong. I can also give you one simple hint for the students preparing for UPSC examination, that if you read the language of UPSC, you will understand that most of the times the extreme statements, the absolute statements are always wrong. I can say 95% of the times they might be wrong, but there is a possibility sometimes even an absolute statement can also be wrong. So you cannot say that in 100% of the times that is always right, but if you are not sure, if you can take an educated guess, probably it will be mostly wrong. All fundamental rights are directed only against the state. Not all the fundamental rights, because again it is an extreme statement, not all the fundamental rights are directed only against the state, because some of the fundamental rights are also against the private individuals. Say for example, abolition of untouchability, child labor, human trafficking. So these are all not only against the state but also against the private individuals. So which of the statements given above is or correct? So the correct statement would be what? Neither one nor two. Option D is the right answer. Please come to the next question, that is question number 13. So statement 1. No constitutional amendment can take away any of the fundamental rights. So can the constitutional amendments take away the fundamental rights? Of course, the constitutional amendments can take away the fundamental rights, because we have seen that a constitutional amendment is not a law under Article 13. So if a constitutional amendment is violating any of the fundamental rights, the courts cannot declare that to be invalid. So definitely a constitutional amendment can take away the fundamental rights. Say for example, the 44th Constitutional Amendment Act 1978 has taken away the right to property. Right to property was taken away by this amendment. And the court has not struck down this particular constitutional amendment. So definitely a constitutional amendment can take away the fundamental rights. And to say no constitutional amendment can take away the fundamental rights would be wrong. Constitutional amendments are considered to be law under Article 13 of the Constitution. When you say constitutional amendments are considered to be law under Article 13 of the Constitution, that is again not the right answer, because by the 24th Constitutional Amendment Act 1971, it has been now explicitly mentioned in the Constitution that a constitutional amendment is not a law under Article 13 of the Constitution. So this is also wrong. Which of the statements given above are incorrect? So incorrect would be both 1 and 2. Option C is the right answer. Please come to question number 14. Under Article 14, who are all entitled to enjoy the fundamental rights? That means under Article 14, who can enjoy the fundamental right that is guaranteed under Article 14 of the Constitution? That is, the state shall not deny any person. That is a word that is used in Article 14. The state shall not deny any person equality before law and equal protection of laws. When you read that particular statement, the state shall not deny any person equality before law and equal protection of laws, which means the word persons include citizens, aliens, and also the legal persons. So that is basically you'll have to understand. So who are all the people who will exercise the right under Article 14? Citizens, aliens, and legal persons. Citizens are citizens of India. Aliens are people in India, but they are citizens of some other country. Legal persons are entities like companies, corporations, and all those things. They are also protected under Article 14 of the Constitution. So choose a correct answer from the codes given below. The answer is option D. D is the right answer. Come to next question, question number 15. Which of the following policies is or examples of affirmative action of the state in India? Affirmative action means these are all policies which are in the nature of positive discrimination. So policies which are in the nature of positive discrimination are usually what is called as affirmative action. Positive discrimination means these are policies which are discriminatory in nature but in favor of backward, in favor of vulnerable sections, in favor of people who are depressed classes. So for them it is favorable, but it may be discriminatory to others. So this is basically what is called as affirmative actions or positive discrimination, which the state is allowed to do under Article 15, Article 16, and also by the principle of what is called as equal protection of laws under Article 14. Now, what is equal protection of laws under Article 14 is saying? It is not talking about equally treating everyone in all circumstances. It is only talking about treating equals under equal circumstances or treating equals as equals. So this principle is also applied in Article 15, which talks about no discrimination on the one hand, but it also allows the state to take welfare measures for the empowerment of women and children. Article 16, if you talk, on the one hand, it is saying that nobody shall be discriminated when it comes to public employment, but it allows the parliament to make a law to reserve certain jobs based on residence, to reserve jobs for the scheduled caste and scheduled tribes and the backward community, to reserve jobs in promotions as well. So these are all examples of what is called as affirmative actions. So reservations in jobs and educational institutions, of course, yes. So this is done by the state under Article 15 and Article 16. Article 15 educational institutions, Article 16 jobs. Reservation for women in local body elections, yes. Today in Panchayat and municipal elections, minimum 33% seats has to be reserved for the women. That is also true. Reservation for women in the Lok Sabha assembly elections, that is state legislative assembly elections, that is also true. Now this provision was recently added in the Constitution. And if you know the answers, any of the students, if you know the answers who are watching this video, you can put it in the comment box by which constitutional amendment this was added. That is reservation to women in the Lok Sabha elections and the legislative assembly elections. But all the three answers are right. This is the latest amendment. I am giving you a hint. Choose the correct answer from the codes given below. So the right answer is option D. D is the right answer. Come to question number 16. What are all the grounds on which discrimination is protected under Article 15 of the Constitution? So Article 15 generally talks about the state shall not discriminate on certain grounds in its policies. What are the grounds on which it shall not discriminate? It shall not discriminate on the grounds of religion, race, caste, and then place of birth, and also on the grounds of what is called as race. religion, race, caste, sex, and place of birth. These are the 5 grounds on which Article 15 says that the people shall not be discriminated by the state. So residence is not a ground and language is not a ground under Article 15. So 3, 4 and 5 are right here. So the answer would be option C. C is the right answer. So these are all areas probably you'll have to keep it in your mind. So come to next question. Consider the following statements. Article 15 as a fundamental right is available only for the citizens and not for private individuals. This is true. Article 15 is available to whom? Article 15 is available only to the citizens. So this is definitely true because Article 15, if you talk about Article 15 as a fundamental right, it is available only to what is called as citizens. Because we have seen Article 15, 16, 17, Article 15, 16, 19, 29 and 30 is only for the citizens. Article 16 is available both against the state as well as the private individuals. No, Article 16 is also available only against the state. So to say both, it is wrong. So this is definitely the wrong answer. So which of the statements given above are correct? The right answer is option 1 only. So Article 15 as a fundamental right is available only for the citizens and not for the aliens. Instead of private individuals, I am making a small correction here and not for the aliens. So that would be more appropriate in this particular question. So with that, you read this particular statement. So you read this particular statement in such a way that Article 15 of the fundamental right is available only for the citizens and not for the aliens. So that means it is not available for all the persons, and to whom Article 15 is available is only the citizens. And to that extent, statement 1 is right, statement 2 is incorrect. But see, the question is asking what of the following is incorrect. So in that case, 1 would be wrong and option B, 2 only would be the right answer. So this is how usually students make a mistake. So even I am making a mistake. So it is very important that we read each and every statement that is given in the question. Till the last word, you will have to read the questions. Consider the following statements. The term untouchability is defined in the Constitution. So under Article 17 of the Constitution, untouchability is a punishable offense. Abolition of untouchability is basically a fundamental right. But however, untouchability is not defined in the Constitution. It is only through various judicial interpretations and judgments we understand as to what is untouchability. Untouchability is basically any form of social disability imposed upon a person by virtue of the individual belonging to a particular caste. So it is not defined in the Constitution. The state is absolutely prohibited from conferring any form of titles to its citizens. While Article 18, so untouchability is dealt in Article 17 of the Constitution. Titles are dealt under Article 18 of the Constitution, while Article 18 prohibits the state from conferring any title, but it doesn't mean that no title can be conferred. There are few exceptions to this. What are the exceptions under this? The exceptions include military and academic titles. The state can confer military and academic titles, but apart from military and academic titles, no other form of titles can be conferred. But to say absolutely prohibited, that would be wrong. So what would be the answer here? Which of the following statement is correct? So the answer is option D, neither 1 nor 2. Which of the following rights are enforceable both against the state as well as the private individuals? We have already seen that. When you say which of the following is enforced both against the state as well as the private individuals, Article 14 is only against the state. Article 15 is also only against the state. Article 16 is also only against the state. But however, Article 17, if you see, it's both against the state as well as the private individuals. In fact, in Article 15 also, if you see, Article 15 clause 1 is only against the state. Article 15 clause 2 is both against the state as well as the private individuals. But if you see completely a particular article which is both against the state as well as the private individuals, it is Article 17. So I would say that the most appropriate answer. Sometimes you can see more than one answer can be right answer. But however, if you see the most appropriate answer in this particular case, that would be option D. That is Article 17 is the right answer. Come to the last question for today's discussion. Statement 1, reservation in promotion is an enabling provision under Part 3 of the Constitution. Of course, reservation in promotion is today guaranteed under Article 16 Clause 4A. And this reservation in promotion is merely what? This reservation in promotion is merely an enabling provision. That means it enables the state to provide what is called as reservation in promotions. Okay, so that is definitely true. Under the Constitution, reservation in public employment can be provided purely on economic grounds. That is also very much possible. In the original Constitution, if you see that there was no ground to give reservation in promotion purely on economic grounds. In the original Constitution, reservation was to be given in public employments for the backward community and to the scheduled caste and scheduled tribe. And that is not on economic grounds, but on their social and educational backwardness and the historical deprivation over a long period of time. But after the 103rd Constitutional Amendment Act in the year 2019, now the reservation not only in the public employment but also in the educational institutions can be purely given on economic grounds for the economically weaker sections among the general category. So that is also true. So this is today given by virtue of Article 15 Clause 6 in educational institutions and Article 16 Clause 6 in case of public employment. So which of the statements given above are correct? So the right answer would be both 1 and 2. So both 1 and 2 is the right answer in this particular case. So with that, we are coming to the discussion of this particular practice questions as well. Very, very useful session. You can just revise the previous lectures, and if you watch this practice question, it will be immensely useful to you. So with that, I'll wind up the lecture. So tomorrow we'll come up with a new topic in fundamental rights. We'll deal with Article 19 of the Constitution. So we'll move to the next theme, that is right to freedom. And in that we'll take up Article 19. We'll try to touch upon the different rights that is given in Article 19 of the Constitution. So with that, I'll wind up the session for today. And one small request before I wind up the session. If you have any of your friends or family members who are preparing for UPSC IAS examination or any of the other competitive examination, you can refer them this particular series and channel, and it will be immensely beneficial for them watching this particular series, and of course the content in the YouTube channel, that is the IAS Mentor. So thank you very much. Keep watching. All the best.